Hello everyone, welcome to Master's Reach. And today we are going to discuss about the property law, in which we are going to discuss about the fourth, and which is very useful for the people who are preparing for the LLB examination. In this section, we are going to explore the important topics from the Transfer of Properties Act 1882. So we are going to understand the property rental agreement, that is lease, trading property, that is the exchange, giving property as a gift, and the legal rights to claim certain assets, actionable claims. Okay, do stay tuned. So let us see what is a lease meaning and definition. So the legal definition is that according to section 105, the Transfer of Properties Act 1882 explain that a lease allows someone to use property for a set time or forever by paying rent. The main part of the lease are the right to use the property, a clear time period, the payment, and the relationship between property owner, that is lessor, and the person using it, that is lessee. So the essential nature in the meaning of lease. So a lease is a simple an agreement. It gives the person renting, the lessee, and the temporary right to use and enjoy the property. However, the original owner is the lessor and keeps the full ownership. Okay, so key parts of a lease. Okay, two sides involved. There must be a landlord and a tenant. Property. The lease is for a building or a land. Using, not owing. The tenants get to use the property but does not own it. Payment mode. Rent or a payment is agreed upon. Set a time. So the lease is a specific time or ongoing until ended. So the types of lease. Okay, lease forever. So that means it lasts forever, has no end date. Lease for a set of time, for a specific period, as written in the agreement. Renew lease. So automatically renew like monthly or yearly until someone's end it. Flexible lease. So can be ended by either owner or by the renter anytime. Okay, so landlord and the tenant, what they call. Okay, just wait. What See, the landlord and tenant, that they can do and what they must do. So here the landlord rights and responsibilities, here tenants rights and responsibilities. What is the landlord rights and responsibilities? Rights, so collect the rent, check the property, end the lease if the rules are broken, get the property back. And responsibilities, let the tenant live peacefully, keep property safe and livable, fix major problems. The tenant's rights and responsibilities: rights, live in the property without problem, make approved repairs, give the lease to someone else if allowed. Responsibility: pay rent on time, use the property legally, keep the property in good shape, don't cause any trouble, give the property back when the lease ends. Okay, here we'll check next slide. So lesser's right explained. So the right to rent. So the lessor, the owner has to receive the rent payment on time as agreed. Right to inspect. The owner, the lessor, check the property to ensure it's keep well and rules are followed. Right to end lease. So end the rental agreement if the renter breaks the rules after giving notice. Right to get property back. Get the property back when the rental agreement legally finishes. So the termination of lease in the following conditions. So merging interest, so giving notice, breaking rules, giving up, time runs out. So ending a lease as explained in a specific section, as a law has its clear rules. Then Forfeiture of lease. So what happened if uh, what it mean, why it happened? So forfeiture means, this means the landlord ends a lease early because the tenant broke the rules of the agreement. Reasons: this can be happen for the reason like not paying rent, breaking other parts of the lease agreement, challenging landlord's ownership, making unapproved changes into the property, using the property for illegal activities. So what happened next? So the tenant loses the right to the property. The landlord can then legally take the property back. They must give proper notice as required. Law section 111G. Okay, then exchange meaning and essential. So, as per the section 118, the definition is, it's when two people swap properties, they can each give up ownership of their old property for new one. So two properties, the people involved must legally own their properties and able to make exchange. Immovable property, only immovable properties can swap, like land or building. Mutual transfer, so both the parties must change ownership at exact same time. So, gift meaning and definition. What is gift? Section 122 explain that a gift is when someone, the donor, freely gives the property like land or other belongings to another person, the donee. This property must already exists. The owner must be legally able to give it, and the donee to their representative must accept it. Nothing is given back in payment. Okay, this is about the unit 3. Kindly go through this particular video again and again. It will be useful for your UG Senate examination or regular academic examination. Thank you. All the best. We'll see you in the next uh, lecture. Okay. Thank you.